Hello guys, and welcome back to my second class where I'll be talking about the Court of Appeals decision in the case of Iwuchukwu versus Nwizu. So let's move straight to the class. Now, according to Ogundade JCA, he said, throughout the hearing, the respondent did not provide a separate contract governing his appointment as director. I am satisfied from the totality of the evidence before the lower court that the respondent was not more than an employee who had been promoted and whose contract of employment as regards its termination is stated in Exhibit 16. Exhibit 16 there is his contract of employment as special assistant, and Exhibit 16 says that if the appellant's employment is to be terminated, it can be terminated by 3 months notice or 3 months salary in lieu of notice. Do you understand? Now, Ogundade JCA continued and said, when an employee like the respondent has been lucky to get accelerated promotion, he does not, for that reason alone, cease to be an employee. He earned salary per annum. He reported daily for work in the office. He was subject to the control of the first appellant, whom he agreed was his overall boss, and yet he argued he was not a servant. Are you listening? I want us to follow what Ogundade is saying so that we can understand why he arrived at his judgment. However, he said out of naivety, I think he said, that is in the trial court while he was being deposed, that is when he was being cross-examined, I think he said that his membership of the board of a company in which he had no shareholding was for life. Now, what they were saying is that because he did not have a period of office, he was saying that his membership on the board was for life because there was no contract. Do you understand? Don't forget that there was no contract. He was only elevated to sit on the board. Now, the Ogundade JSC said, I think otherwise. I agree that the respondent remained all through a servant and that the contract of employment was determinable by 3 months notice as stipulated in Exhibit 16. Now, the learned justice considered the provision of Section 175, which is very, very important to us, particularly Section 175 subsection 6 of the Companies Act 1968, which is now our own Section 288. The first thing that we need to do is to read what does Section 288 sub 6, which is their equivalent in our own comma. What does it say? It says nothing in this section is taken as depriving a person removed under it of compensation or damages payable to him in respect of termination of his appointment as a director or of any appointment terminating with it as director. The most important part, or as derogating from any power to remove a director which may exist apart from this section. Which means that Section 2886 gives a company the ability to have a specific provision apart from Section 288. If they don't want Section 288 to apply, then another provision can apply, which can be stated either in the contract of employment or in the articles. While trying to interpret this provision, Ogundade said, I am of the view that the effect of Section 175 sub 6 of the Companies Act above is to make it unnecessary for the ordinary resolution to be passed where the person is to be removed as a director is subject to an agreement which makes it possible to be removed notwithstanding the provision of Section 175. So he is saying that once there is a contract that shows how you should be removed, therefore automatically that one will prevail. Then the respondent in this case was not a director appointed by any fixed term, so there can be no question that he is being removed. Why did he say that? Ogundade JCA looked at the provision of Section 2881. You know, in Section 2881, it says a company may, by ordinary resolution, remove a director before the expiration of period of office. He is saying that if there is no period of office, it means you are not a director. That is what Ogundade JCA is saying here. He said the respondent in this case was not a director appointed for any fixed term. There can be no question that he has been removed before the expiration of his period of office. He was put on the board of the second respondent at the sole wish of the latter. He derived the position by virtue of his employment, that is, as special assistant. If the employment came to an end by determination, as in this case, the respondent would, in my view, without further ado, lose his position as a member of the board. The simple question here is, was the respondent a director who had an employment contract with the second appellant, which said contract stipulated how the employment could be determined? If he was, then he came within the ambit of section 176 of the Act, and it would not matter that his name has been registered in the Register of Companies or that his name appeared in the letterhead of the second appellant. There could not be any infraction of the rules of natural justice involved if the employer determines the employment in accordance with the period of notice agreed between the parties. Now, you see, the basis for the decision of the Court of Appeal is that you are telling us now that you are a director. But according to section 288, the provision that you are relying on, it says that the company can remove a director by ordinary resolution before his expiration of office. Mr. Director, sir, do you have expiration of office? No. Do you have period of office? No. So why then are you coming to say that you are a director? You were only allowed to sit on the board at the wish of the company. It doesn't make you a director. It's a contract to be a special assistant, and that contract is determinable by 3 months notice or by 3 months salary in lieu of notice. You have been given this notice, Mr. Director. You don't have any contract that shows that you are a director. You have been given the notice that terminates your employment. Therefore, what are you still looking for? Do you understand? You don't have period of office. You don't have contract of employment. You don't have alternative. You don't have anything. All you have that can be shown before this court is your contract that stipulates that you are special assistant, and it also stipulates how they should remove you, and they have removed you. Therefore, Oga, come and be going. Do you understand? That was what the Court of Appeal held. In my next class, we will interrogate the argument of lead counsel for the removed director, the argument for lead counsel of the company, as well as the Supreme Court judgment. It's going to be very interesting. I will see you in my next class.